Hello and welcome to Fair Housing for Property Managers. We're going to give folks a few minutes to join and then we'll get started. Very excited to see all of you. We've already gotten a few housekeeping questions in the chat, and I'm going to be answering all of those questions momentarily. So just hang tight and we'll be there. There's no need to mute yourself. Everybody who's not a panelist is automatically muted. So no need to worry. And we do that because it would be very hard to get hundreds of people to mute. So, but thank you for asking. And so chat is disabled, but Q&A is going to be enabled, so you can ask any questions on Q&A. It just makes it easier for us to keep track. And we disabled chat just because every now and then we get somebody that isn't supposed to be on the webinar and might write something inappropriate. So I hope that's all right with folks, but there will be lots of time for questions. And I'm going to get things started in about 20 seconds. Thank you. All right, well, let's get started. Hello, everybody. It's nice to meet you. My name is Kara Brodger. I'm a senior fair employment and housing counsel at the newly name-changed California Civil Rights Department. And I am just going to give you a little bit of information. I'm going to let my co-hosts introduce themselves in a minute. But we do have some amazing speakers from the California Department of Real Estate who we're so excited to be partnering with. I'm going to move on to the next slide. So just a few things before we start, because I know everybody has these questions. We're going to provide a copy of the PowerPoint. There's going to be a link in the chat. It'll be, we're going to figure out, it's going to be a link in the chat for the PowerPoint, but you won't be able to like write back on it. So the chat's disabled for this webinar, but that doesn't mean that we can't post things ourselves. So you can go on there and download the PowerPoint. We're going to be recording this webinar and we will post it on our YouTube link, and we'll send a follow-up email a few days after this training, so you can have the link to the PowerPoint, you can have a link to the YouTube video. If you're looking for MCLE credit, we're going to give you the link for that. And it sounds like folks just wanted like proof of attendance. So we'll figure out something on that end, and we'll send you information on how to get that with our follow-up email in a few days. So that's about it. Oh, I'm gonna just encourage folks to ask questions in the Q&A. It's really easy for us to keep track of questions there, and it'll allow us to you know, do it throughout the webinar. And also we give it a time for questions at the end. So now I'm going to hand it over to my colleagues over at DRE.
Well, thank you, Kara. Chika, do you want to introduce yourself first, and then I'll go at it after that?
Perfect. Thank you, Steve. I'm Chika Sundquist. I am the Assistant Commissioner for Enforcement at the California Department of Real Estate.
Hello, everybody. I'm Steve Lerner. I'm the Chief Counsel at the Department of Real Estate. And on behalf of Chika, we're very excited to partner with our a longtime sister agency, but now the newly named department, the Civil Rights Department. So as Kara mentioned, they were formerly known as the Department of Fair Employment and Housing, and they have rebranded, and you'll hear a bit more about that as we go through our presentation. But we're very excited for this inaugural partnership, where we are talking to you all now about fair housing in the property management context. So just some disclaimers at the beginning. I'm an attorney, so it comes in something I do normally and as a matter of routine. I go through these disclaimers. Today's presentation from all of us is intended for informational purposes only. We don't intend to change any policies or create any new rights or policies. And we are not giving legal advice, and we are not creating any type of attorney-client relationship. But with all that, please take this as informational, and I hope you find it educational and informational and learn something from today's presentation. And I think I speak on behalf of all the presenters that we're more than happy to answer questions both at the conclusion of today's presentation, as well as you know, by email sent to our various departments should you have any questions. So with that, I'd like to have, I think Kara is driving our slideshow presentation. So Kara, would you be so kind? Perfect. So Chika, do you want to take these next couple slides?
That'd be great. Thank you, Steve. So let's start with what's the Department of Real Estate's role in fair housing. And our mission is to safeguard and promote the public interests in real estate matters through licensure, regulation, education, and enforcement. And then we have California Business and Professions Code section 10050.1 that reinforces that protection of the public is the highest priority for DRE. And that means that we at DRE must ensure that consumers are protected from discriminatory practices in real estate matters. Next slide, please. Then let's talk about what's fair housing. Well, it's the ability of persons of similar income levels who are seeking housing in a similar market and who have similar qualifications to have available to them the same range of housing choices, regardless of race, color, national origin, religion, sex, familial status, disability, age, ancestry, sexual orientation, gender identity, gender expression, genetic information, marital status, citizenship status, primary language, or immigration status. I'm going to turn it back over to Steve to discuss the fair housing laws.
Thank you, Chika. So there are essentially a bunch of laws that govern this area, but the two primary laws at the federal level are the Federal Americans with Disabilities Act and the Federal Fair Housing Act. And then at the state level, there's a bunch of laws likewise that govern this area. But the three biggest players for state legislation is the state's Unruh Civil Rights Act, the Fair Employment and Housing Act, and the Holding Act. I just want to walk quickly through these acts just to explain sort of what they do. You can play along at home. For those of you that want to take a guess, when do you think the Federal Americans with Disability Act was passed? Well, if you answered 1990, you'd be correct. So that act came into existence in 1990. And it's kind of hard to believe that for the better part of almost 200 years, 175 years, we didn't have any type of Disabilities Act of this broad reach on our books at the federal level. So Congress and the president enacted this one in 1990. Moving on to the Federal Fair Housing Act. If you want to take a guess of to yourself when you think this act was passed, if you guessed 1988, you'd be correct. But I want to spend more time on the three state laws. So the three state laws are the Unruh Civil Rights Act, the Fair Employment Housing Act, and the Holding Act. So with respect to the Unruh Civil Rights Act, it covers much of what the Federal Americans with Disabilities Act covers, but it's more expansive. And so here in California, there's more protections for individuals. And in some future slides, we're not ready to switch slides just yet, but in a future slide, you'll see a list of what we term protected classes or characteristics. And you'll see a bunch of those that are covered by these various statutes. And then on the second slide, you'll see additional characteristics that are protected by the Unruh Civil Rights Act. But just to give you a quick background, the Unruh Civil Rights Act, if you guessed to yourself, 1959, that's the year that this act was enacted. And it specifically provides protection from discrimination by all business establishments, including housing and public accommodations. And so it covers specifically 14 different types of classes or characteristics. However, the California Supreme Court has ruled on several occasions that the act is not limited to just those 14 characteristics, that it can be interpreted and applies beyond the 14 characteristics. And so, like I said, in a few moments, you'll see a slide that covers quite a few of the characteristics that we're talking about today. So moving on to the civil rights, well, I should say, before I jump off of the Unruh Civil Rights Act, the Unruh Civil Rights Act is basically enforced by our sister agency, the department, the Civil Rights Department. And there are penalties for violating the Unruh Civil Rights Act. And penalties can be no less than $4,000, or no less than $4,000, but can exceed or go all the way up to potentially 3 times the amount of actual damages. And so the department, Civil Rights Department is the lead agency when it comes to enforcing the Unruh Civil Rights Act here in the state of California. Switching now to the Fair Employment and Housing Act. If you guessed what year this was enacted, if you guessed 1959, you'd be correct. It came about in 1959. And this act created the Department of Fair Employment and Housing, which is now named the Civil Rights Department. And just to put it in context, so our Civil Rights Department friends have been in existence for about 70 years, give or take, if my math is correct. And just for comparison's sake, the Department of Real Estate was enacted, legislation was enacted all the way back in 1917, which was that particular legislation was determined to be unconstitutional. So the operative law that created our responsibilities started in 1919. So the Department of Real Estate has been around for quite a while and came into department status about 2 or 3 decades after 1919 with a specific act creating us. So both our friends at the Civil Rights Department and here at the Department of Real Estate, we have been around for quite a while, and we've been doing what we do quite well for a long time, and we hope to continue doing that. Speaking about the next act, the Fair Employment and Housing Act, this act applies to public and private employers, labor organizations, and employment agencies. And it protects from discrimination, retaliation, and harassment in the employment and housing arena. And there's 2 thresholds. One threshold, it has to do with anti-discrimination, and that applies to 5 or more full-time workers. And then the anti-harassment applies to 1 or more employees. And like I said, this is the act, the Fair Employment and Housing Act, that created the Department of Fair Employment and Housing. And finally, the last of the 3 big state acts is the Holding Act. This act governs essentially housing financing. So it governs provisions of loans to purchase, to construct, to rehabilitate, to refinance from anywhere from 1 to 4 units that are occupied by the owner, or to make home improvements to any structure that has 1 to 4 units on it. So if I could have the next slide. Perfect. This is the first of 2 slides that identify the characteristics that are protected by the various statutes. And you can see that the list is quite expansive. If you take a moment and look at this, and like Kara mentioned, the entire slideshow will be available on both departments' websites following the presentation, and will be placed into the chat. But so you don't have to jot it down. But if you take a quick look, there's quite a few protected characteristics here. But Kara, if I can have you switch to the next slide. And these 4 are specifically covered by the Unruh Civil Rights Act. So with these 4 plus the characteristics on the prior page, California provides great protections to a large group of its citizens and residents. So with the next slide, These are statistics taken by our Civil Rights Department friends back when they were the Department of Fair Employment and Housing in the year 2020. And so what this shows you is the number of complaints that then the Department of Fair Employment and Housing received. So on this slide, you'll see that they received 880 filings or complaints that covered violations across 1,652 bases or characteristics or classes. So you could have one filing covering more than one of these protected characteristics. And based on the numbers you can see on this chart, and we'll have a second chart that shows you some of the other characteristics, but disability seems to be the largest. But you also see on here significantly, there's race, there's sex and gender. So the Department of Fair Employment and Housing receives a large number of complaints annually that they investigate. And you can see from this slide, and Kara, if I can have you flip through slowly to the next slide, the slide after that, you can see a breakdown by characteristic of the housing complaints received in the year 2020. Terrific. And with that, if you can flip to the next slide. And so here at the Department of Real Estate, we have a regulation in place. It's called Commissioner's Regulation 2780. And this specifically addresses our license population. And just before I go into this, just to give you a little background, we require a real estate license for engaging in certain activities. We call these activities license activities that you need a license for. And that's basically the selling or buying of real property for another in expectation of compensation. And the same is true with respect to renting or seeking to rent or assisting in the rental of property for another in expectation of compensation. And there's a few other characteristics, but those are the two for today's presentation that are most relevant. But the reason it's relevant, this slide is relevant to you all, is for our licensee population, those of you that are licensees that are attending this presentation. These are things you should be aware of, because if you're found to violate this regulation, you could both receive discipline to your license by the Department of Real Estate. And when we receive complaints and learn of cases that we investigate, we do refer cases over to our sister agency, the Civil Rights Department, and they could follow through and seek to enforce violations against you as well. So these, it's a long laundry list that's provided in this regulation, but I highlighted in these next two slides some of the more relevant ones for today's presentation. But it's basically, when it comes to discrimination or anti-discrimination or non-discrimination, if you show a property, you should show the property equally to all people, and shouldn't show some or talk about some aspects of the property to one group of people and ignore that aspect of the property to a different group of people. And it goes through these examples. Same thing with processing applications. You should treat all applications equally and fairly. Don't favor one set of applications over another set of applications. Also, when you make representations about the property, make sure the representations are accurate, but also make sure that the representations are being made to all people interested in the property. And Kara, if I can have you flip to the next slide. And here are some more examples of what this regulation covers. And so you can see it for yourself. But essentially, I would strongly encourage all licensees to be very familiar with Regulation 2780. And we just amended this regulation, and with some additional steps and requirements to give the department sort of more teeth to enforce violations of fair housing laws. And those new amendments to the regulation actually will take effect starting on Saturday, October 1st. And so that all that information can be found on the Department of Real Estate's website if you're interested. So with that, Kara, if you flip to the next slide, I'd like to pass it back to Chica.
Thank you, Steve. We don't get a lot of complaints as it relates to discrimination. And I take that as a great thing that property managers and licensees out there are providing fair housing and fair lending practices to their clients and consumers. But that being said, we do receive some complaints related to discrimination, which we take very seriously. As it relates to the property management world, one common discrimination related complaint we receive is that a prospective tenant is letting us know that they're not being approved for a particular rental. They believe because they're being discriminated against based on a protected characteristic or protected class. Another common complaint we receive is that a tenant is not being shown a particular property because of their protected characteristic. And finally, we receive complaints about unprofessional behavior by property managers. For example, we'll receive a complaint that someone representing the property management company was making direct discriminatory comments to a person based on their protected characteristic, or they were insinuating that a person's ability to rent a property would be affected by that person's protected characteristic. And of course, when we receive a complaint related to discriminatory practices, as Steve mentioned, we will work with our partners at the Civil Rights Department to ensure that all of the issues related to the discriminatory practices are addressed. And someone who has a lot of expertise on that is Kara from the Civil Rights Department, and I'd love to turn the presentation over to her.
Thank you so much, Shika. Thank you, everybody. This has been a fantastic turnout, and keep those questions coming on the Q&A. We're going to answer, I think, all of them in the presentation that I'm about to give. Just as Stephen said, I'm also an attorney, and this is our disclaimer. Again, this is just for informational purposes. We're not establishing policy rights. This is not legal advice. The opinions expressed by the presenters don't necessarily reflect the opinions of CRD. So, as you've already learned, GFEH is now the California Civil Rights Department. This is a very new name change as of July 1st. The reasons behind this are many, but mainly I think it just really better reflects the work we do. And a lot, folks felt like it was a barrier because we don't just enforce laws on employment and housing. We enforce laws that address things like hate violence and human trafficking and, just general, the ability of, people to access healthcare free from discrimination. So we thought this was a much more fitting name for our department. And this is just a little bit about us. We're California Civil Rights Agency, and our gigantic mission is just to protect the people of California from unlawful discrimination. And here's all the different areas that we do it in, not just employment and housing, although that's a big part of our work. And our responsibilities. So we do public outreach and training and technical assistance to everyone, and that's what we're doing right now. We also investigate discrimination complaints and cases of systemic discrimination. A lot of times those complaints are mediated, so we do a lot of dispute resolution to try and work those complaints out. And we also do enforce the laws that we enforce in civil court. So sometimes we will bring a court action when we think it's appropriate. So with that, I'm going to move on to our first topic, which is emotional support animals. And when I do presentations, I do like to do some things that are interactive. And so I'm going to start with a poll, and I just ask that you answer. It's completely confidential. No one's going to know whether you get the right answer or not, but I think it's just really interesting to kind of see what people think. So if you could put up poll number 1. So who can provide documentation of a person's need for a reasonable accommodation? So choose one choice. A, the requester, B, a licensed medical professional, C, a therapist, D, a social worker, E, the requester's parent, child, or relative, F, all of the above, or G, answers B, C, and D, the medical professional, therapist, or social worker. So I'm going to give folks about 30 seconds to answer, and then we'll figure out, we'll see what people answered. So. And Ellie, when we have a good amount of participation, you can go ahead and switch it over to the results. All right, so we had 2% say the requester, 13% said a licensed medical professional, nobody chose a therapist or social worker or their parent or relative. We had 33% choose all of the above, and the majority of folks, 52%, said B, C, and D, so medical professional, therapist, or social worker. So, and the answer is all of the above. So, and I'm going to elaborate on that moving forward, but actually all of these people, including the requester's parent, child, or relative, licensed medical professional, although it does not need to be a licensed medical professional, therapist or social worker, can provide that documentation. So, and I'm going to talk about this in the context of emotional support animals. One, because it's honestly one of the biggest complaints and I think areas that folks want information on, but also there was a new law that passed that confused people a bit, so I'm going to talk about that as well. So I'm just going to give some info on emotional support animals, and then I'll go into a bit about documentation. So an emotional support animal is an animal that provides emotional, cognitive, or similar support to a person with a disability. They're often, and they often help people assist or manage the symptoms of their disability, and they're often referred to as comfort animals or support animals. As many of us know, and I'm not going to go into the nuts and bolts of reasonable accommodations on this presentation, but if somebody has an emotional support animal, they're considered to be, it sounds weird, but a medical device. So pet rent is not something that can be charged. But housing providers can have reasonable limitations if they enforce them to all residents. What this means is, rules like if you have a dog and you bring them out, you have to clean up their waste, or, just things that are reasonable, and, you would enforce them as to everybody. Contrary to popular belief, or maybe not popular as much anymore, there actually is no registry for emotional support animals. They don't have to wear identifying tags or vests. A lot of the websites that purport to do things like that, they're actually just taking money from people because there is no registry. There's no reason to have to do that. In AB 486, it was a law that was enacted last year. It made things really confusing. It talks a lot about emotional support animals needing to be certified by a licensed medical professional with a certain amount of time in their relationship with a patient, but the law does not apply to any of the protections we're talking about. AB 486 does not impact fair housing law, which means that a licensed medical professional is not required to provide documentation for a reasonable accommodation, including an emotional support animal. So yeah, it's a very confusing law, but the main thing you need to know is that it doesn't impact fair housing rights, including all the rights that we're going to talk about today. So, and let's talk about service animals as a contrast, because I feel like it's helpful to kind of compare and contrast these two. So a service animal is different in that it's an animal, it's usually a dog, that's trained to perform specific tasks to assist an individual with a disability. It can include like a physical disability, a sensory, psychiatric, or intellectual or mental disability. A great example is, guide dogs for the blind, or helping people with low vision. Signal dogs are also common. They alert people who are deaf or hard of hearing to sounds. So service animals, in contrast to emotional support animals, are specifically trained. They are, because they're trained in they're under more of a registration process. There are rules around what you can and can't ask as far as a service animal versus an emotional support animal. With service animals, you really can only ask if the person who has a service animal has a disability and what tasks that their animal provides. So it's really different from emotional support animals, but we're really just going to be talking about that. And I already touched on this, but again, AB 468 did not impact the laws that we're talking about today. And there's a quote from the law just to show you. So let's just talk really quickly again about documentation of the need for an accommodation. Again, it does not have to be from a licensed medical professional. It can be from any reliable third party who is in a position to know about the individual's disability or the disability-related need for the requested accommodation. And our department, the California Civil Rights Department, we have now called the Civil Rights Council. and they make regulations interpreting civil rights laws that we enforce, including the Fair Employment and Housing Act. And they actually did a really great job of doing really extensive housing regulations. A lot of them address people with disabilities in housing, and that reliable third party comes right from the regulations. And, you know, those regulations talk about, you know, that it can be any reliable third party. And, you know, the regulations also talk about, they give some factors to consider to decide whether somebody is reliable or not. So, you know, and it's really, you have to look at it on a case-by-case basis, but, you know, any reliable third party could be a social worker, a therapist, a peer support group, a non-medical service agency, so maybe like a caseworker, you know, and this is where it comes into parent or caretaker, someone with a caretaker relationship for the person with a disability, like a parent, family member, in-home support worker or roommate, because if they're the one taking care of that person, you know, they're going to have a really good idea about, you know, why a reasonable accommodation would be necessary. And, you know, another that I didn't put on this list is the requester themselves. You know, often they're in the best position to describe why, you know, the accommodation is necessary. And if, you know, their disability is obvious or readily apparent, if somebody's in a wheelchair, for example, it's going to be really obvious, you know, why, and that they are disabled. So they could also just provide that documentation. So let's do a hypothetical. And I'm going to go ahead and read it and just talk through it. So Rowan has a mental health disability that makes it difficult for him to get out of bed, leave the house, and to do other tasks necessary for himself. His therapist recommends that he get a dog to motivate him to get out of the house and to provide companionship. Despite his building's no pet policy, Rowan adopts a pit bull mix. The dog motivates him to get out of the house for walks, and Rowan even notices his mood improving. The building's property manager sees the dog and serves Rowan with a notice saying he must get rid of the dog or he will be evicted. Rowan mentions he would like to keep the dog as a reasonable accommodation, and the manager responds, "You should have thought of that before you got the dog." He also adds that he would never let a pit bull live on his property because they are dangerous. So the two questions that I'm going to address are, one, can the property manager refuse the reasonable accommodation? And, you know, the property manager here is, you know, saying, you know, you should have gotten the dog first, you should have requested it first, it's too late. So one, I want to acknowledge that I can understand why that would be really frustrating for the property manager, because in this case, you know, Ron, you know, should have probably, you know, asked for the accommodation before they got the dog. But the law also says that you can request a reasonable accommodation at any time. It can be before a tenancy starts, it can be during a tenancy, it can even be, you know, if there's an eviction case in the court, it could even be after, you know, the judge says, you know, the owner, you know, gets possession of the unit. Anytime that the person's still living in the unit, they can actually get a reasonable accommodation. So there's no like, you're too late. But at the same time, you know, there are best practices, and, you know, it's obviously much better before getting a dog to probably ask for the accommodation. So, the manager here probably could not refuse the accommodation as long as Rowan can show a disability-related need. But can the property manager refuse to allow the dog because it's a pit bull? So that's a little bit more of a sticky question. I'm going to go into direct threat. So I'm going to answer this question after giving you a little bit of information. I hope you're appreciating my very vicious looking dog on the left-hand side. So direct threat, an accommodation can be denied if it would constitute a direct threat to the health or safety of others. It would cause substantial physical damage to the property of others, and the risk can't be lessened or eliminated by another reasonable accommodation. So, you know, if a dog or another animal, you know, that specific dog is a direct threat to health or safety, then that accommodation could be denied. But it has to be evaluated on a case-by-case basis. It has to be, you know, based on objective evidence as to that animal. It can't just be, you know, all pit bulls are dangerous. You know, there can't be breed restrictions. You know, some pit bulls are really great. You know, the only time I've ever been bit by a dog was from a Chihuahua. So, you know, tiny little dog. So it really depends on, animals, and it has to be evaluated on a case-by-case basis. So the manager in this hypothetical can't have a breed restriction, but if they had reason to believe that this particular dog would be a direct threat, then they would be able to deny the accommodation. And I'm actually going to just address one more thing with the direct threat before we go into source of income discrimination. One thing I want to add is that some insurance policies will have breed restrictions in them, and those restrictions actually violate fair housing law. I can understand why a housing provider would be frustrated, but the insurance company itself is violating the law, and it does not provide an excuse to deny a reasonable accommodation. But those clauses should be rendered null and void, because you can't have a breed restriction in an insurance policy. So moving forward, I'm going to talk a bit about source of income discrimination. We had a lot of great questions in the Q&A about this, so I'm excited to jump in. And let's just talk about, what do we mean by source of income? So source of income means income that's paid directly to a tenant, including, from work, from public benefits like SSI, paid to a representative of the tenant. Some tenants, or some people, have what's called a representative payee. It's somebody that manages their money for them. Or paid to a housing owner or landlord on behalf of a tenant, like Section 8 vouchers. The payments are made directly to the housing provider. So this means that a property manager can't discriminate against a tenant based on how they will be paying for their rent. But it is permitted to ask where income comes from and how much someone makes, for purposes of kind of screening somebody for income eligibility like you do for anybody else. But you can't use this information to discriminate. And I'm going to give you some examples. And we're going to go into poll number 2, Bashir, to kind of talk through this a little bit. So Bashir has a Section 8 voucher and applies to rent a unit from Ariel. Ariel looks over Bashir's application and says he can have the apartment. The next day, Bashir gives Ariel paperwork from the housing authority to fill out. Ariel gets annoyed and tells Bashir she has no problem with him using Section 8, but she is not filling out the paperwork. So did Ariel violate fair housing law? So I'm going to give folks like 30 seconds, and then just feel free to show the results when we have a good amount of participation. All right, yes, 88%, and no, 12%. So the answer, that 88% of you got it right, is yes. And let's talk about why. So source of income discrimination isn't just like, hey, I'm not renting to you because you have a Section 8 voucher or because you're on SSI. It also includes, refusing to fill out paperwork or comply with the paperwork, or, to provide certain documentation that allows somebody to get rental assistance. Advertisements also, we've all seen them on Craigslist, but they'd say no Section 8, no HUD, no public assistance. Those are also unlawful, and we actually have a program that we've been doing for a little while, where we've been actually having somebody scrape all those ads online, and then we send people letters to tell them to take those advertisements down. So we are paying attention to that. Or if there's an existing tenant and they were admitted and living in the property, and then they receive a voucher, refusing then, that's also source of income discrimination. Imposing different requirements for properties where people use Section 8. Even cities or counties, who won't fund housing developments because people are going to be using housing assistance. So, it's pretty broad. So it can be any number of these things. And I'm going to talk a bit about this, if housing providers are required to accept all applicants using housing subsidies. And then I'm going to talk a little bit, I'm going to answer a bit of a question that we've received in the Q&A. So are housing providers required to accept all applicants using housing subsidies? So No, landlords are still free to consider other lawful factors when analyzing a rental application. And this includes, you can still analyze someone for income eligibility, their credit history, and their rental history. As long as the reason that you're denying the person is not because they're using a voucher, then, as long as it's something that you apply, standards that you apply to everybody, then that would not violate the law. But one thing to note is there's actually a provision in California law that says if you're analyzing the income of someone with a housing voucher or rental assistance, you can only consider, whether the person, you can only consider the person with the voucher's portion of the rent. So, for an example, and I'm including it here. So Raul applies to rent an apartment. The rent is $2,000. And the housing provider has a policy to only accept tenants who earn 3 times the monthly rent. Raul's portion of the rent is $200, and the voucher will cover the rest. This means the housing provider can only consider if Raul earns 3 times his portion, which would be $600. And I actually provided the citation because I think that's a provision that I think a lot of people don't know about, but the idea being that, Raul, it would make it impossible for Raul to rent because the reason he's getting the housing voucher is because he can't afford to pay market rent. So, we know that the housing authority is going to continue paying their portion, but if you want to screen and make sure Raul is going to do his portion, you're only going to consider what Raul's portion is. I'm going to go, actually don't know how to go back, so I'm just going to address an area. So there are many questions in the Q&A about accepting Section 8, and I understand property managers' frustrations because sometimes housing authorities are really slow to process paperwork. It can be a challenging process, and we recognize that. I think, what I would say is as long as you are applying the same standards to all tenants, then, it wouldn't be considered discriminatory. So, take that as you will, but, it's, as long as you're applying the same standards for like, timing and when, getting things moving, you should just consider that as far as, whether you're being discriminatory. I will add that housing authorities are willing to expedite when they can. They recognize, a lot of housing authorities are understanding of the fact that this has been a problem and are taking steps to make it better. And, it is really important to open up housing opportunities to everybody. So, take that as you will, but I understand where the frustration is coming from. But we do want people to be able to use their vouchers if they can. So moving on, criminal background checks and fair housing and criminal history. This is a hot topic as well. So let's do another poll. Jordan is applying for an apartment. The application includes a criminal background check. A few days after Jordan puts in his application, the rental office calls to tell him the application has been denied because he has an arrest on his record for theft. Jordan was never convicted of theft. Did the housing provider violate the law by excluding Jordan because of his arrest? Let's put up the poll. All right, let's see. Yes, 87% said yes, and 13% said no. So what is the answer? Yes. So there are certain types of information that housing providers are prohibited from considering as to criminal history information, and this includes arrests. There is actually guidance done by HUD in 2016 that really, talks about kind of why looking at arrests by themselves is not an indicator of whether somebody has committed a crime. I mean, it's kind of the pillar of our criminal justice system in that, someone has to be proven guilty to be, to have committed a crime. And so arrest records, the guidance says, do not constitute proof of past unlawful conduct and are often incomplete. For example, they fail to indicate whether the individual is prosecuted, convicted, acquitted. So, and I'm going to talk more about accuracy of criminal records. The fact of an arrest is not a reliable basis upon which to assess the potential risk to resident safety or property posed by a particular individual. So let's talk more. So here's a list of criminal history information that housing providers are prohibited from considering when screening applicants. So arrests that didn't lead to a conviction, we've already talked about that. Information kind of, indicating that someone was questioned or apprehended, taken into custody, but like if they weren't, they weren't charged and convicted, then, that, should not be considered. Infractions, a lot of people do get referred to pretrial or post-trial diversion programs. Things like, they'll call it like drug court or mental health court. If somebody gets referred to that, often, there won't be a conviction, and as long as they go through the program, so that wouldn't be considered on its own unless someone's convicted. Convictions that have been sealed, dismissed, expunged, anything that happened or is processed in the juvenile justice system. So let's move forward and let's talk about criminal history that can be considered. So directly related convictions can be considered by a housing provider in screening an applicant. So a landlord can only deny housing to people with criminal histories if they have a directly related conviction. And this means a criminal conviction that has a direct and specific negative bearing on a substantial, legitimate, and non-discriminatory interest or purpose of the housing provider. And again, this is taken directly from the regulations that the Civil Rights Department Council put together. And I'm going to provide you some citations. So let's talk about what we mean by directly versus non-directly related. These are pretty clear examples. I know that in real life, it's not always this clear, but for purposes of this, I'm going to use these examples. So a directly related conviction would be an applicant was convicted of intentionally burning down a home 2 years ago. That would pretty clearly show that it's a credible threat to the health and safety and residents of the residents or the property. That would be directly related. It happened 2 years ago. It involves burning down a residence. That's very dangerous. So it's likely that conviction would be considered to be directly related. And non-directly related. An applicant was convicted of a DWI 10 years ago. Driving drunk in and of itself, not a great thing to do, but it's not really directly related to a threat to health or safety of the property, especially because this happened 10 years ago. There's been a really long time since it happened, and, it's likely that a DWI wouldn't impact the property itself or the residents there. I mean, I guess it could, but I think there's a pretty decent argument that that would not be directly related. So under those circumstances, that DWI should not be considered. So let's talk about disparate impact. I'm going to get a little lawyerly on you, and I apologize. But there's a reason, there's a method to this, to my madness. So disparate impact means it's basically that a housing provider's policy or practice regarding criminal history, it will violate California law if it has an unjustified discriminatory effect on people with protected characteristics, even if there's no intent to discriminate. So I like this cartoon because I feel like it kind of describes what we mean by disparate impact. So it's very silly, but I'm going to just go over it really quickly because I think it's helpful. So this person is saying, I give my cat more food because I like cats more than dogs. And then the person says, that's bias against dogs, and that's disparate treatment. It's like very clear that that person is biased against dogs in favor of cats. So very clear. But disparate impact would be, I give my cat more food than my dog because I heard that animals that purr need more food. So, and the person says that's bias against dogs, and the person who does it says I didn't mean it. So, it's having a disparate impact on dogs, and the person didn't actually mean to discriminate against dogs, but it's still having a discriminatory or disparate impact. So I hope that's helpful. And why am I telling you this? So why do policies that exclude people with criminal histories have a disparate impact on people with protected characteristics? So the reason that there are protections for people with criminal histories, you know, and limitations to, you know, the information that you can consider is because, you know, policies that exclude people with criminal histories have a huge impact on people with certain protected characteristics. One of the big ones being people of color. So if you look at statistics, almost 70% of people in prison are people of color, and Black Americans are 5 times more likely to be in jail or prison when compared with white Americans, and 3 times more likely to be arrested. And nationally, 1 in 81 Black adults in the US is serving time in state prison, and 1 in every 10 Black men in his 30s is in jail or prison. Latinx men are 2.3 times more likely than white men to be incarcerated. It also, policies that exclude people with criminal histories also discriminatorily impact people with disabilities. So people with disabilities are 44% more likely to be arrested by age 28 when compared with the population as a whole. And this increases to 55% for Black men with disabilities. And I've included all the sources here if you want to take a look. Most of these sources are pretty recent. Nearly 1/3 of all people in prison have a psychiatric condition, so a disability that's serious enough to require regular treatment. So again, you know, people with disabilities are disproportionately impacted by the criminal justice system. So if you have policies that exclude people with criminal histories, they essentially become policies that, you know, discriminatorily exclude people with disabilities, people of color, people with other protected characteristics. And criminal records are also often inaccurate. So, you know, if you are going to screen for criminal history, you know, and we have some handouts that I'm going to provide links to, but, you know, it is important to allow an applicant to provide mitigating information. If they say that the criminal history information that you relied upon is wrong, you know, it's important to allow that person to dispute that criminal history. And this is why. Criminal records are just known to be completely inaccurate. There was a large study a few years ago that found that at least 30% of the participants in the study had at least one inaccuracy in their criminal records. So pretty much 1 in 3. 28% of participants had an entry on their record that should not have appeared because the charge was dropped, dismissed, or, you know, was just absorbed as part of, you know, a plea bargain. A lot of people were also found, or 5% had duplicate entries. So the same conviction or criminal history was entered more than once, making it look like the person had a more extensive criminal history. You know, often too, people's names are wrong, or spelled wrong. People with the same name will get, you know, it'll come up for this one person whose name is John Smith, even though it was for another John Smith. So it's not an accurate science. So that's another reason why it's very important to consider people's mitigating information. Also, you know, rates of recidivism decrease sharply after 3 years. So the longer a person is out of jail or prison, the less likely they are to reoffend. So when they hit about 3 years to 4 years, it becomes pretty much the same as the population of a whole. So the likelihood of someone going back to jail or prison after, like, I think it's about between 5 and 6 years, your likelihood of going back to jail or prison is about the same as the criminal conviction, or likelihood of going to jail or prison is the same as you know, society as a whole. So again, you know, another reason why you should only consider directly related convictions. You know, if someone's been out of jail or prison for 7 years or 8 years, you know, the likelihood of them going back to jail or prison is very low. And, you know, that should be taken under consideration. If the conviction was from a year ago, you know, that's that might be taken under consideration in a different way. You know, that could show propensity for somebody reoffending. So just some information on criminal history. So I hope you find it helpful. Again, I didn't get into the nuts and bolts of every aspect of, you know, criminal history screening, and I'm happy to answer questions, but we do have a few really helpful handouts on our website to help kind of guide housing providers in this process. So, all right, moving on. So, fair housing and childcare providers. Oh, we have 84 questions. I guess we'll have a lot of time or a lot of questions to address during Q&A, which would be great. Poll 4, Lynn. So Lynn puts in an application to rent an apartment from Sasha. Lynn mentions that she will be using the house to run a small licensed daycare. Sasha denies her application, stating that the other tenants will be unhappy about the noise from the children. Did Sasha violate fair housing law? All right, we have 71% that says yes and 29% that says no. And the answer is yes, Sasha did violate fair housing law. And these are protections, I think, that are less known in general. We actually put out some guidance about a year ago on this particular issue because we found that a lot of people don't know about them. It's an issue that doesn't come up as much as some of the other issues that I'm talking about. So, but we still want to address it and talk about it. So what you need to know is that landlords actually can't refuse to rent. They can't evict or raise the rent on because a tenant is opening or running a licensed family childcare home. And tenants can care for up to 6 children with a small family childcare license, or up to 12 children with a large childcare home license. So we're talking about licensed childcares. They do have to be licensed to get this protection. You know, and they also apply to purchasing or renting a home. Specifically, you know, a home subject to a homeowners association. So, you know, if you're looking to purchase a condo and you're denied by the HOA because you're going to run a childcare, that would violate this law as well. So insurance, you know, landlords or HOAs can't require a tenant to purchase liability insurance because they're operating a childcare home. You know, and insurance companies again would be violating fair housing law if they canceled somebody's insurance because they were operating a licensed family childcare. So that was just a little quick reminder. And again, we have more information on this on our website under our resources, which I'm going to be sharing at the end. And we'll also, links to those will also be included in the PowerPoint that we're providing to you. So just to keep that in mind. Okay, so harassment. This is our last big section. So we're talking about harassment of tenants. So there are several types of harassment. I'm just going to quickly go through them so we have time for Q&A. But quid pro quo is basically, it's like asking for something else. So basically, you're requesting or demand a person do something that they don't want to do in order to get them to maintain housing. So for an example, a landlord tells an applicant he won't rent her an apartment unless she goes on a date with him. That was actually straight from a case that I worked on. The conduct is unlawful whether or not the applicant said she'll go on the date or not. It's basically just conditioning housing on, you know, forcing somebody to go on a date with somebody, or hostile environment. So basically harassment that's just severe and pervasive, and it interferes with someone's use or enjoyment of housing. So this impacts maybe somebody's, you know, after they move in, and, you know, they're being harassed to the point where they don't want to live there anymore, and it doesn't feel like a safer or healthy place to live. You know, it doesn't require a change in conditions or privileges of housing. You know, it doesn't require things like the housing provider says, I'm going to raise your rent if you don't go on a date with me. But, you know, it could just be harassment. For example, a tenant repeatedly refers to another tenant with unwelcome racial or gender derogatory slurs. So again, that's harassment. You know, it's so pervasive, it's making the person uncomfortable, maybe making the person less able to enjoy their home. Maybe it makes them want to leave. And harassing behaviors, they can be verbal, physical, visual. They can involve coercion or intimidation, threats. They can even involve revealing private information without their consent. So, and a good example for this presentation is, you know, if you as a housing provider receive confidential information about someone's disability for a reasonable accommodation and you disclose that to people, you know, you said, hey, do you know that so-and-so was diagnosed with schizophrenia? You know, that would also be considered harassment. That's confidential information. And harassment based on a protected characteristic. So additionally, it's harassment when harassment can violate the laws that we enforce, the fair housing laws, if someone is specifically targeted because they're of a protected characteristic. So example, a tenant paints a swastika on the door of another tenant who they believe to be Jewish. A maintenance person employed by the apartment complex makes demeaning and unwelcome sexual comments about another resident. A landlord threatens a family of tenants with deportation while yelling ethnic slurs. So those would violate the Fair Employment and Housing Act. And who could be a harasser? So this is some important information. Harassment based on a protected characteristic can be committed by a housing provider. The housing provider's employee or agent, so like a maintenance person, probably some of the property managers on this call or on this webinar, but also a third party, such as another tenant, another resident, a guest of a tenant or resident, or a contractor hired by the housing provider. So let's do another poll. So Isabel and Alma. Isabel and her daughter Alma live in an apartment complex. Alma has Down syndrome. One of the residents has been making offensive comments about Alma's disability when they walk by. It has gotten so bad that every time Alma sees this person, she runs away in tears. Isabel asks the property manager to do something to stop this harassment, and he tells her, "You're both adults, work it out yourselves." The building's lease includes rules that prohibit tenants from engaging in any form of harassment against staff or other residents. Does the housing provider have a duty to act? So I'm going to put the poll up. All right, let's see. For some reason, oh, there they are. Yes, 99%. And no, 1%. So yes. The answer is yes. The housing provider knew about the harassment and chose not to act. The lease also gives them the power to act. You know, the lease has specific provisions in it prohibiting harassment of other tenants. So what are housing providers' responsibilities to stop harassment? So obviously housing providers can't engage in harassment of tenants or residents. And they obviously have to take prompt action to correct or end harassment by their own employees or agents. So that's pretty clear. But harassment by third parties. So as we displayed in the example, housing providers have to take prompt action to correct harassment by a third party if the provider knew or should have known that the discriminatory conduct has the power to correct it. Third parties can be tenants, residents, contractors. The power to correct and end harassment by a third party, it could be in the lease. A lot of leases have, you know, anti-harassment provisions, residential agreements. It could be, you know, part of a homeowners association bylaws, for example. But also, honestly, most or all leases in California do have, it's called an implied, like a covenant of quiet enjoyment. Basically, it's, you know, the housing provider saying, hey, I'm doing what is in my power to ensure that you have use and enjoyment of your residence. So, you know, it could be argued that really, even if your lease doesn't have those rules, that a housing provider would be required to act. And I'm providing the regulations done by the Civil Rights Council to provide more information. And, you know, we also have a harassment prevention guide for housing providers on our website. Again, that's going to be with our resources, but just something to consider. And retaliation. So retaliation, I think many of us understand what that means, but basically, you know, if somebody asserts their rights under FEHA, so say, you know, a housing provider refuses a reasonable accommodation and the tenant decides to file a complaint with us. And the housing provider decides to, you know, raise that person's rent, for example, because they filed the complaint, that would be considered retaliation. You know, if somebody wrote a letter to the housing provider complaining that a tenant was harassing them and the housing provider, you know, served them with a notice or, you know, wrote them up for not doing something just because they made that complaint, that would be considered retaliation. But it can include many things: raising their rent, refusing to do repairs, evicting a tenant, refusing a tenant's access to common areas. You know, it could even apply when, say, you know, a tenant told another tenant about their rights. You know, like I was living somewhere and I told my neighbor was complaining about harassment, and I said, hey, I work for CRD and, you know, you can actually file a complaint. If my landlord then decided to go after me because they were upset that I helped my neighbor file a complaint, that could also be considered retaliation. All right. So I'm just going to talk a bit about how we as CRG enforce these laws, and then we'll go into the Q&A. So we do a few things to enforce the law, and I talked a bit about this at the beginning, but we have a complaint process where we investigate complaints of housing discrimination. We do mediation. Sometimes they go to court. We also have a fairly new fair housing testing program. What that means is, you know, we hire, we contract out with an organization that hires people to go in and test for discrimination. So they'll send, for example, someone with a Section 8 voucher, someone without a Section 8 voucher, just to see how they're treated. And, you know, our initial year of testing, we actually, they did 80 source of income tests, and 38 or 47.5% did show evidence of discrimination. And they did 20 tests based on race, and 50% showed evidence of discrimination. So, you know, discrimination is still happening, unfortunately, which is a lot of why we're, you know, doing this training. And I talked a bit about this already, but we have a discriminatory advertisements project where we scrape the internet, and if we see discriminatory ads, you know, we do write letters and educate the housing provider on what they can and can't put in an advertisement. These are our publications. I plug them throughout. So let's go into some Q&A. And okay, there are so many questions, and I don't know, Chica and Stephen, if you have any you want to answer, or if I should just jump right in. So
please go ahead. We've been trying to address the ones that we could, but most of them seem to be for you.
Yeah, it's fine. There's a lot around Section 8. So let's see. Can a landlord? Let's see. I'm just gonna start looking, and if people have other particular questions.
So Kara, one of the questions I saw in the question and answers, and perhaps you can answer this, with basically service dogs and emotional support dogs, I should say animals, can the landlord charge increased pet deposit? And what happens if the pet is known to be aggressive to other tenants? Do you want to comment on that?
Sure. So you can't charge an additional pet deposit for an emotional support animal or a service animal because they're not considered to be a pet. As weird as it sounds, they're considered to be kind of like a medical device, like think like a wheelchair, for example. That said, you know, if that emotional support animal damages the property, then the tenant would be responsible to pay for that damage. If you know, if the animal is, you know, considered to be aggressive You know, I talked a bit about this under direct threat. If an animal is considered to be aggressive, and you know, it's like objective that, you know, that particular animal is aggressive, you could deny a reasonable accommodation and say, you know, you think it's a direct threat to health and safety of the property, and the other residents. I will say the bar on that is pretty high as far as case law and direct threat is concerned. So you want to be pretty sure that that particular animal is a direct threat, but obviously you have a duty as housing providers to protect the health and safety of the other residents in the property. So, but you know, like I said, the bar is pretty high. You know, an example that I often use is that, you know, one of the cases talking about direct threat, it wasn't about an emotional support animal, but it was about a tenant was served with an eviction and asked for an accommodation due to a mental health disability. And they actually assaulted somebody and gave them like some pretty permanent like physical damage. And they again asked for an accommodation, and the property refused to engage and said, hey, you've done a lot of physical harm to this person, you're a direct threat. And the court found that they should have engaged in the interactive process before filing the eviction. So it's a pretty high bar, but at the same time, I mean, you do have to protect others. So reasonable accommodations are definitely very fact specific. It's really hard to give like a very clear answer about something. So
Here, another question on emotional support and service animals is, are they limited to just one, or can a person request to have more than one animal?
People can request to have more than one animal. Again, you just have to show that there's a disability related need to have more than one animal. You know, that said, if, you know, somebody wants to have 10 cats in a studio, you know, you could put reasonable limitations on things. You know, if it's something that you would apply to everyone, if you're concerned about, you know, damage to the property or the person, you know, just space or, you know, health and safety. I mean, you could say, hey, you know, it's not reasonable to ask to put 10 cats in the studio. I talked to someone recently about how a person had a horse that they wanted to keep in like the common area of this apartment complex, and obviously that's not really a reasonable request. So, you know, because this property was not set up to have horses. So, you know, you can still have some, you know, reasonable reasons to reasonable restrictions for emotional support animals.
So here you address the security deposit for emotional support animals and service animals, but let's switch over to childcare facilities. Can a property manager or a owner charge a larger security deposit for a tenant that has a in-home licensed childcare?
No, because it would be, you know, treating that licensed childcare home differently than you would other tenants. So you know, you have to treat each tenant the same, and, you know, requiring them to have liability insurance, charging a larger deposit would be considered to be discriminatory. But again, if, you know, the kids like write all over the wall and make holes in the wall and, you know, and do damage, that tenant is going to be responsible to pay to rectify all of that damage if it happens. So, so I'm getting a bunch of questions about criminal history. You know, people are basically just like asking specific scenarios. You know, this person, for example, is saying, you know, this person was convicted for theft and served time. Can you deny an application if it proposes a safety issue? So again, I want to reiterate that, you know, folks should really look at criminal history kind of like you're looking at reasonable accommodations. You really want to address criminal history on a case-by-case basis, and you want to allow the person to provide what's called mitigating information. So not only, you know, information about whether it's accurate, but also like, you know, has the person held on a job for a few years? You know, what are other ways the person's rehabilitated? Have they gone through a program? You know, and you want to consider things like, how long has it been? You know, so, you know, this person's like asking, you know, if you were convicted of theft, but what if it happened 10 years ago? You know, the likelihood of you reoffending is pretty low. So you really want to consider different factors. So, you know, it wouldn't, I can't say for sure that you could say anybody convicted of theft would be, you know, okay to deny. And actually, I should have mentioned this in my presentation, but a blanket ban. So saying things like, I won't accept anybody with a theft conviction is also unlawful because you're not looking at the individual circumstances of somebody's conviction. Because, you know, we don't know like, what was surrounding that. You know, we had, you know, another factor to look at is if it was related to domestic violence. Oftentimes people who are victims of domestic violence get kind of swept up into the criminal justice system as well. You know, is it related to someone's disability? Did they get arrested for property damage because they were off their medication? So, you know, you really got to look at all the different factors, or you should, when we have some really helpful guidance to help you through that process. But you really want to just look at like what you think reasonably would really like affect the, you know, property or the safety of the other folks in the housing. And, you know, and I tried to provide you with some info on criminal history because, you know, I want to show you that, you know, just because someone has a conviction on the record, you know, doesn't necessarily mean that they're going to be a threat to safety. And, you know, especially when you think about the timing and whether the criminal history is even accurate or any type of rehabilitation. So it's a balancing act for sure.
Kara, another question I saw in the question and answers asking about insurance. Can a property manager or owner require tenants to carry insurance if they have emotional support animals or service animals, or if they run a licensed childcare on premises?
No, you can't require additional insurance, and an insurance company can't refuse to, you know, provide insurance for housing if somebody has an emotional support animal. You know, I've seen quite a few insurance policies in my days when I was working on, you know, reasonable accommodations, where it would say in the insurance policy, like breed restrictions, no German Shepherds, no pit bulls. And those provisions are actually also unlawful. Also, insurance companies, you know, can't deny insurance to housing providers if one of the tenants is running a childcare facility. They can't require that the tenant have liability insurance or additional insurance, because you'd be treating somebody differently than other tenants. So that's the reasoning behind it. Let's see. You see any others, Stephen? There's so many. Let's see. So yeah, no extra security deposits. I think we got into that already. We're definitely gonna post, we can post the link again for this presentation. Let's see. Let's see. There's so many. So there's some questions again about tenant harassment. You know, again, it's, you know, if you know about it, and you should take action generally. Let's see.
So here's a question for you. We talked about age as being one of the protected characteristics that we can, you know, property owners and managers can't discriminate against. What about the various facilities that are basically senior housing, 55 years in age and older? How are they able to do that when age is a protected characteristic?
So there's actually an exception in the law for properties that are providing housing for folks 55 or over. There's certain characteristics that the property has to have in order to use this type of exemption. I forget what they are offhand, but you know, it's basically that you do exclude all people under the age of 55, and it's exclusive for seniors, but they are allowed to do that. So that's like kind of one of those limited exceptions. Let's see. Let's see. So here's some questions about when reasonable accommodations kind of impact other tenants. So this person's talking about how they had their applicant has a service dog, but the next door neighbor is allergic, which you allow. I mean, I think you got to try and work it out on a case by case basis. And think about kind of if there are steps that can be taken to kind of mitigate, the impact to the existing tenant. I feel like, again, with reasonable accommodations, you really want to like think about them as like, you're trying out different ideas. Maybe you could put an air filter in the hallway. Maybe you could have certain rules for, when, a tenant with the dog, for an example, wants to come outside, and it sounds like, I mean, under those circumstances, I mean, you could, talk to that existing tenant, because it seems like you wouldn't really be like in the same space as that person very often. So, again, I just want to encourage you to utilize the interactive process and talk things through. If you have two existing tenants, maybe getting them both together to come up with a solution. There's ways to do this where, yeah, let's see.
So Kara, another question that's popped up is, and you covered it a little bit in your presentation, but it has to do with who on behalf of the tenant can request reasonable accommodations, and what type of documentation does that third party need to provide, and can they create the documentation themselves, or are they just gathering the documentation from other people to present on behalf of the tenant?
I mean, a tenant, or if, for example, a tenant has a provider that assists them, or the tenant has somebody involved that can help them. I mean, if you receive a request for an accommodation for a tenant, then that's a request. It doesn't have to be under any specific form or in any specific format. I mean, I think if I received a letter from a therapist that said, tenant A is requesting an accommodation, I would probably follow up with tenant A. But as long as the person's requesting it on behalf of the tenant and that's what the tenant wants, then that would be a legitimate request. I would just think of all requests as valid, and you shouldn't, I understand, and I think it is helpful to have certain processes for requests, have certain forms, but you can't require them to be filled out to get a request. As far as documentation, any type of information that person is able to provide, you can't, there are limitations to what you can ask for. If the therapist says, for example, it describes the reason that somebody needs an accommodation and says, it helps them manage the symptoms of their disability, they don't actually have to talk about like what the diagnosis is, what the disability is. You can't really ask for medical records. It's really just a clear indication of, that there's a disability related need for an accommodation. So there's really no like specific form that somebody, has to use. A lot of times people will just write a letter, asking for a medical release under those circumstances is not appropriate, because you don't really need to know all that information. And again, there are some, factors to consider. If somebody went on the internet and got like a letter from somebody that they never met, I mean, maybe you could consider that person not to be reliable. You really need to look at, the facts. If it's a therapist the person's been seeing for 6 months, maybe you would consider them to be more reliable, but you really have to look at it as a case by case basis. And the bottom line is, what I would do is just encourage folks to talk to their tenants and try and work some stuff out. It doesn't have to be like a contentious process. It can just be a conversation. I know it's not always going to pan out that way, but I just encourage you to talk to each other and to kind of try and come up with a solution to a problem. Let's see. Okay. You see any others? There's 200 questions. So I'm like, let's see.
So this is a question that I have. It's not in the questions, but are you aware if local jurisdictions may have either stronger or looser laws governing fair housing and discrimination in California, or does the state law trump all of that?
So you can't have looser laws locally because it has to conform with the state law, but you know, California laws are stronger than the federal laws. We have a lot more protective basis, and some local jurisdictions do have additional protections, and they're able to do that. So an example was before Section 8 was explicitly part of FIHA and source of income discrimination, the city of San Francisco had an ordinance saying that, you know, source of income discrimination, including Section 8 vouchers, is considered source of income discrimination, and that the court found that that was valid. So, you know, there are some jurisdictions that do have additional protections. There are some jurisdictions, for example, that have specific processes for applicants with criminal histories. They have certain ways that, you know, procedures, for example, that allow applicants with criminal histories to use kind of like the same criminal history report for 60 days, for an example. You know, there's, you know, other jurisdictions, you know, that have like rent boards, and they enforce, you know, stronger, some stronger fair housing protections. So, you know, I think there's a jurisdiction in California that protects people based on their size. So like, you know, if they're considered a larger or overweight, they might be protected. So, you know, jurisdictions are allowed to do that. And a law recently passed the California legislature, and there's a lot to it, but basically it is going to allow jurisdictions under some very specific circumstances where it doesn't impact fair housing to have like housing specific for people who are local, to prevent things like gentrification and displacement. So, you know, yeah, there's a lot of things. As long as it's stronger and not less protective, then it's usually okay, unless it violates fair housing law. That was my like very lawyerly answer to that question.
So here's a question. We touched on it briefly before, but this has to do with operating a licensed childcare facility on premises. If the landlord requires all tenants to maintain insurance for on-premise, you know, businesses, that are, can the property manager or the owner require the childcare operator to do the same?
I think as long as you're treating all tenants the same. That said, I mean, if generally the lease doesn't allow for the operation of businesses, then it could look like you were targeting that person running the childcare. But like, for example, a lot of housing providers require renter's insurance. And as long as you're requiring everyone to have renter's insurance, then, you know, that would be allowed. You just don't want people to be treating tenants differently because they're operating a childcare. And it looks like we're almost at time. Maybe we could do one more question. And God, I wish I could answer all of these questions. Let's see. I think.
Here's a question you may know the answer to, or if you don't, let us know. But if the landlord made adjustments to a house to accommodate, or a rental property to accommodate a tenant, for instance, installing a ramp, when the tenant moves out, who's financially responsible for removing the ramp?
So that's a very, I do know the answer. It's definitely an area where reasonable modifications are a whole other beast. We're actually in the process of putting out guidance about that, reasonable modifications, and I think it would be a great topic for another training. You know, with reasonable modifications, most of the time, if it's a modification to the exterior, it's not in the tenant's unit, then the tenant would not be responsible to pay for it to be taken down. If it's in the tenant's unit, then they may be responsible, but it's a much stickier, it's an area with like a lot of exceptions, but you know, I'm happy to do an additional training on that because I feel like it is an area that people have a lot of questions.
Then the final question is, both the Department of Real Estate and the Civil Rights Department have a lot of information on their websites. What is the website address for the Civil Rights Department? And after you give yours, Chica and I will give the Department of Real Estate website address.
Okay, I'm gonna go back because it was just here.
So as you're doing that, the Department of Real Estate website, for those of you with pen and paper handy, is dre.ca.gov.
And we're calcivilrights.ca.gov, and we can provide that in a subsequent, like in our email that we're going to send out, because we'll send you another link to the PowerPoint and a link to the recording, and we'll also figure out a way to show kind of proof of attendance. But we'll probably, you know, make sure that someone actually attended to give them proof, because we can see who participated and who didn't. So, but yeah, we're happy to do that. And I super appreciate everyone's time. This was a great presentation. We had about 500 people on, which is amazing. You know, and 208 questions is amazing. And I'm definitely going to look at all of them to kind of see if there are things, questions in there that could help enhance some of the materials we're providing, and maybe we could do subsequent trainings, because it seems like there's a lot of interest. So I really appreciate your attendance, and I want to thank the folks from the Department of Real Estate that are here, Chica and Stephen, and you know, thank you so much for your partnership in this. And do you have anything else you want to say, Stephen or Chica?
No, thank you very much for joining with us on this inaugural presentation. We enjoyed it, and we hope to do more in the future. So thank you, everybody, for participating.
Thank you. Take care.